Welcome, everyone, to this webinar on forced labor supply chain law in Canada, Guide for Importers. My name is Dan Kisselback. I'm managing partner in Vancouver for Miller Thomson, and I am also the leader of the Global Trade and Customs Group. And with me today, I'm pleased to have our friend Dave Pentland, Vice President at Carson International. This is one of a series of presentations that we've been doing on hot global trade and customs matters. And I want to thank you for joining us today and to invite you. I believe we'll have a questionnaire possibly at the end to tell us how we're doing. Now, next slide, please. This is just legal advice. Please don't run off and use this information as background information. Anything that you need to deal with a particular fact pattern or situation, please consult with a professional. Next is Dave's bio. Dave, over to you.
Yeah, good morning, Dan. I'm going to make some of my comments very brief today. Suffering some kind of bubonic plague, but you're in good hands, Dan. I will jump in and between barking with a few comments when I can. My name's Dave Pentland. I'm Vice President of Carson International. I look after trade compliance issues, trade agreements. When the bad guys come knocking at your door, either U.S. Customs or Canada Customs, and then I'm happy to be doing this presentation with Dan. Dan is a fellow that I've come to rely on for the last 20 years or more when the heavy lifting becomes beyond what a customs broker's scope is. And I lean on Dan to get involved and roll up sleeves and take matters into their hands on a legal perspective. So looking forward to the presentation today. I've done a few of these privately for some of our import clients, but looking that we have over 200 people registered today. So looking forward to a lively session. So take it away, Dan.
All right, on to the next slide. And me, I've just explained who I am, managing partner in Vancouver, leader of the Global Trade and Customs practice, practiced 35 years approximately in this area, and licensed in New York, Ontario, and BC. So on to the next. Let's get the show on the road here. Bill S-211, Forced Labor and Child Labor in the Supply Chains Act. This is a relatively new piece of legislation. It's just coming on the radar for folks. Many folks have not known too much about this legislation. The takeaway for all this is that the time for dealing with compliance is now. Reporting is required by May the 31st. This is transparency reporting legislation. It's part of an effort within Canada and within a number of other Western countries, especially to focus on ESG and reporting and transparency. So it's a transparency legislation with strong links to legislation in the UK, Australia, and France. You know, the U.S. implements several measures to combat modern slavery in supply chains, including its Tariff Act and a list of goods that are prohibited goods in the U.S. And so this approach to improve upon transparency in the supply chain has gone through a series of different iterations, and it's evolving over time. We're at this particular point now where reporting is required as of May the 31st. And when the government gets information, feedback from the folks that do report, I imagine that this program will evolve, and we'll have a little bit more information about that as we move along. Right now, there are questions even within the legal bar about what some of the provisions mean and what is the meaning of certain provisions which are not defined under the Act. And so the government has gone through a process of issuing guidance in addition to the legislation to help interpret what is going on here. So over to the next slide here. So the legislation defines child labor as meaning labor or services provided or offered to be provided by persons under the age of 18 years, and that are provided or offered to be provided in Canada under circumstances that are contrary to the laws applicable in Canada, and are provided or offered to be provided under circumstances that are mentally, physically, and socially dangerous to them. So this requires a bit of understanding of what the Canadian laws are, because if you're benchmarking child labor to what are circumstances that are contrary to the laws applicable in Canada, you should understand what the legislation requires in Canada. For example, children in BC, you can't have children working under 12 years old unless they have a permit. So it's useful to have a good understanding of what BC or Ontario or Canadian law requires, so that you can understand whether or not there are circumstances in the supply chain that are contrary to the laws applicable in Canada. Now, I'll get to this in a little bit while, but one of the difficulties is that when you're importing, you might not have access to all this information. And so all you can do is report on what you've done to address the issue. And so we'll talk about that in a little bit. On to the next slide, please. Again, under the definition of child labor, things that interfere with schooling by depriving them of the opportunity to attend school, obliging them to leave school prematurely, or requiring them to attempt to combine school attendance with excessively long and heavy work, and constitute the worst forms of child labor as defined in Article 3 of the Worst Forms of Child Labor Convention. What are those things? Well, really egregious things like sale of a child, trafficking in children, recruiting them away from their families, debt bondage. Some of they're very serious things that intuitively we would think they're things to avoid in Canada, at least. Next slide, please. So forced labor. There is a definition of forced labor in the Act. Labor or service provided or offered to be provided by a person under circumstances that could reasonably be expected to cause the person to believe that their safety or the safety of a person known to them would be threatened if they fail to provide the labor or service, or constitute forced or compulsory labor as defined in the Forced Labor Convention. The convention indicates that forced or compulsory labor is all work or service which is exacted from a person under the threat of a penalty, and or for which the person has not offered himself or herself voluntarily. So anything is work done under the fear of a penalty is an example of compulsory or forced labor under the convention. Next. So who is subject to the Act? What are the entities that are subject to the Act? And that's being a bit of an area of discussion within the legal bar, partly because the Act it doesn't always define some of the terms, such as who's an importer. It doesn't really say that. Maybe it's because Parliament or the drafters of this legislation thought that it was obvious or explainable in another piece of legislation. So Section 2 of the Act is where you go to find the definition of entity, and it's a firm that's listed on the stock exchange, or it has a place of business in Canada, does business in Canada, has assets in Canada, and based on its consolidated financial statements meets at least two of the following conditions for at least one of its two most recent financial years. Over the next slide, please. And it's got to hit one of these two of these three. It has $20 million in assets. It has generated $40 million in revenue, or it employs an average of 250 employees. So you've got to hit two of the three, and then you're included as a covered entity. I'll call it a covered entity. Also, a covered entity could be one that's prescribed by regulations. So there are ways to become a covered entity under the Act. Next slide, please.
Actually, Dan, before we move on there, it's worth noting that this is global revenue as well. So
Correct. Yeah.
we've actually had a number of people say that they have small operations in Canada. However, the global sales by far meet those requirements. And I think you reached out on behalf of a law society asking that question, and they came back and said it's global revenue. So
yeah, exactly. If you're a covered entity, then we got to look at, do you have an obligation to report? Because that's the whole point of this act. And Section 9 helps us with the answer to that. It tells us who has reporting obligations. And it says that the obligations apply to any entity, A, producing, selling, or distributing goods in Canada and elsewhere, importing into Canada goods produced outside of Canada, and controlling an entity engaged in any activity described in A or B. On to the next slide, please. So if the entity falls within A, B, or C, then it's got a reporting obligation. And one of the questions that comes up or has come up to me in the past is, who's an importer? And there is case law, and there is an approach that the CBSA takes as to who is an importer. And an importer under the Mattel case is a person who has titled goods at the time that they're imported into Canada. And the CBSA indicates that it will consider the person to be an importer if that person is listed in a B3 or an equivalent document, the Canada Customs Coding Form, and uses its BN number, its business number, the number that it is issued when it has a customs account opened. So that's for commercial importers. On to the next slide, please. So this is the point that David was making, that you've got to consider the consolidated financial statements. And so the use of consolidated financial statements means what? Well, the reporting entity's revenue, assets, and employees include the revenue, assets, and employees of any entity it controls. So you've got to take a look at what is the reporting entity control, and you include, for example, subsidiaries. So it's the group that you consider when you're considering whether or not the entity is a reporting entity under the legislation. The reporting entities' revenue, assets, and employees do not include those of which any entity that owns or controls it. So you don't include the parent, but you do include subsidiaries. And this was a topic of some discussion and guidance that was issued by the government. I think it was in early January. Next slide, please. So again, size-related thresholds refer to global assets, not restricted to assets located in Canada. Revenue is not restricted to revenue from business activities in Canada, and the number of employees include those residing in or employed in Canada or in another jurisdiction. So assets are, excuse me, to be calculated on a gross basis, not a net basis. Next. So what's the definition of an employee? They say that it has the same meaning as in Canadian common law. And Canadian common law for those who didn't go to law school, is an employment is a contract of service where work is done as an integral part of the business of the payer. This is opposed to a contract of services. Independent contractors are contract of services. So an employment is a contract of service. So you're engaged under an employment contract to do things, usually. So that's one way of looking at it. Okay, we had some interesting development there. I'm just going to move along here until we fix this problem with the slides. But the next issue is, what is control? Control includes both direct and indirect control, and it extends down the organizational chain. So there's something called de facto as well as de jure control. And de facto control is whether or not you control something or an entity in fact. And de jure is whether by law you have control. So if you have, say, 51% of the shares in a company, you would have control by law. So the government considers control as both direct and indirect. And deem control under another section. There's a section 10, which says that deem control is important. So control impacts the definition of an entity. For the on slide 17, if we'll send you the slides afterwards, I suppose. For example, in the case of franchisees, whether a franchisor needs to report depends on whether or not it controls within the corporation sense any entities engaged in activities described in section 9. And whether a franchisee needs to report depends on what activities the franchisee is engaged in. That is, activities such as importation, covered by section 9. So I'm on slide 17. We'll move on to 18. So what's the reporting process? Entities that must develop a report have to meet the requirements of the Act. And there's provisions that spell out what is it the government's looking for. And I imagine that there's a team of folks that are going to be reviewing this information. And to some extent, the information is standardized, and we'll get to this, but there's a questionnaire that kind of gives you the standardized responses format, and then there's a report, and you have to include the questionnaire in the report, and in the report you can say anything else that doesn't get captured by the questionnaire. So entities must develop a report that meets all the requirements of the Act. And you have to consult internally and externally to gather the information, obviously, that you need to fill out the questionnaire. It's important that the report is approved by whatever appropriate governance is in place for the entity. And these are large entities, so often it will be a board of directors or some similar situation. And it has to be attested to. So somebody has to sign off that it's true, accurate, and complete, and included in the final. It's a PDF version of the report that's submitted, so it can't be changed. Next, please. So entities must complete, as I mentioned, an online questionnaire. There's a standardized set of questions that the government wants to drill into. It makes it, I guess, a little bit easier. One would have thought possibly a desirable way of approaching this would be to just have one document, but there's two. And there's a questionnaire and a report. I guess because the government wants to have standard questions answered, and they're also giving an opportunity to companies to say other things that are not covered in the questionnaire. So the questionnaire includes open and closed-ended questions that address the requirements. And one thing that is vital is to ensure that the information that is provided in the questionnaire is consistent with the information provided in the report. You don't want to have an internal inconsistency, because that could be something that drives unwanted attention to you. So next, please. At the end of the questionnaire, entities have their answers. They'll upload the attested to report before they select submit. And once the entities have completed and submitted the questionnaire, including the report, a confirmation will appear so that you know that the job is done. It's important to make sure that the job is done because there's penalties that are in place, not only for the entity, but for directors and officers for the failure to provide a report in a timely way. So, that it's not just the company's problem, it's the directors and officers' problem. Entities will publish their submitted report on a prominent place on the website. This is an important feature of this as well. I guess the thinking here is that by encouraging and requiring entities to publish the report, they will be encouraged to do more and report more. Now, you can't obviously make stuff up. This is reporting for the last financial year. So if there's not much that was done, then that's just the way it is. But on a go-forward basis, I think the government's hoping and expecting that entities will do more in the following year and so on. A copy of the report is made publicly available by Public Safety Canada in a searchable online catalog. So there are, customers, investors, stakeholders that will be interested in looking at these reports to see, which companies are taking this issue seriously. Next, please. So we set out some of the requirements that are specified in the report. The section 11 to 11.3 are the big ones. It deals with the structure and activity of the supply chain and the policy, the due diligence processes, and parts of the business that carry risk. And you can't write a book. It has to be within 10 pages, 20% pages if provided in both official languages. There is, I guess, a data issue for this as well. That's specified in the guidelines that it will only accept so much data. So the questionnaire can serve as a report template, and it probably should, because you want to make sure, again, that the questionnaire is consistent with whatever you say in the report. And as I mentioned as well, the filing of an online questionnaire is mandatory. Next, please. So the next slide focuses on the areas that carry risk, and reporting requirements deal with information that each entity is subject to. Section 11.3, I'll just mention some of the things that are included in there: the structure, activity, and supply chain, the policy and due diligence processes, the parts of the business that carry risk, any measures taken to remediate forced labor or child labor, any measures taken to remediate the loss of income of most vulnerable families that results from a measure taken to eliminate the use of forced labor, child labor, and its activities, the training provided to employees on forced labor and child labor, how the entity assesses its effectiveness in ensuring that forced labor and child labor are not being used in the business and supply chain. So it's quite detailed. And as I'll mention later on, one of the issues is how do you get this information if you are an importer, right? Because you don't have control over this, and you're, somewhat dependent upon what you get from your supply chain partners. Sub 4, 11.4 deals with the approval of the report. In the case of a report in respect of a single entity, just say the Canadian company, it has to be approved by the governing body. In the case of a joint report, either the governing body of each entity is included in the report, or the governing body of the entity that controls the entities will have to sign off. Okay. And there'll have to be some attestation, as we mentioned, that shows that this is validly done. Next, please. So this all has to be done by May the 31st. And if you haven't started, it's a good time to get going on this thing, because it'll take time to think through and deal with some of the questions, undoubtedly. And so you have to refer to the steps taken in the previous financial year to prevent and reduce the risk of forced labor. So it's not what you will do or are doing now, it's what you did. So it's a historical account. And it deals with, as I mentioned, the structure and activity in supply chains and policy and due diligence processes. Next, please. So it really, the focus will be on the parts of the business that carry risk. Next. And then remedial measures, that will probably be important to the government as well. If it's not perfect, what are you doing to fix it, and take care of the issue going forward? Also, it deals with effectiveness. How do you assess the effectiveness of your measures in ensuring that forced labor and child labor are not being used in the business and supply chain? It's one thing to say that you've received a certification from your business partners, but is that going to be enough knowledge? These are open questions. Next, please. So there's some mandatory and optional questions. So there's two schools of thought about how to deal with this. One is give the government just what it asks for, and that's it. And the other is, in order to avoid unwanted attention, it's best to answer all the questions, including the voluntary ones. So it depends on where you land on this thing. In many cases, the folks that I've dealt with will try to answer as many as they can, right? And some of the questions might not be answerable. There is a 1,500 character limit, so you can't, as I mentioned, write a book on this thing. Next, please. So, as I mentioned at the beginning, this legislation in Canada is similar to other legislation in the UK and Australia, and they overlap. And in some cases, a Canadian company that wants to comply under our legislation may be able to extract information or use a report that has been filed elsewhere. That's great. You can do that. But you have to make sure that all the questions are answered. It's not just good enough to use the report that was filed elsewhere and say we're done. You have to pay attention to what the questions are in Canada, because there may be additional questions that are not answered in the foreign report. So it's important to keep that in mind. And that simply makes the point that you have to make sure that compliance is met with our current legislation. Next slide, please. A complete report will be internally consistent. We'll have an attestation that somebody with the knowledge and responsibility at the appropriate level will sign off on. The Act doesn't require the disclosure of sensitive information that would expose a company to legal risk or can promise privacy of persons. And there's not a requirement to report on specific cases or allegations of forced labor or child labor. So identifying information about the entity obviously is going to be required so that it can be tracked. The legal name, the reporting year, any identification of a revised report, the business number that you get from the Canada Revenue Agency, the identification of any joint report, say if it was filed in the UK or Australia, identification of reporting obligations under other jurisdictions, that kind of information. Additionally, the entity categorization, say it was an importer, the sector or the industry, say it was e-commerce, and location, where is the principal place of business. Entities must address the requirements in section 11 as well, which we went through 11.1 and 11.3 previously. Next slide, please. So this 11.1 describes this, refers to the steps that have been taken in the previous financial year to prevent and reduce the risk of forced or child labor in the production of goods. Next. And 11.3 is the structure, activities, and supply chains, the policies, due diligence processes, and parts of the business that carry risk. And these are additional factors that we've referenced. So on to the next.
Actually, Dan, can you just go back to the last slide?
Yeah, sure.
I think it's worth pointing out note 5, because that's one that kind of jumps out that I've talked to a number of importers on.
Yeah. This, I don't know how many firms are going to be able to get into this information. And we've talked about this privately between you and I, David, about how much information is available and how much information is enough. It may be that it's not answerable, right?
Right. Yeah, I mean, I'm concerned that before, if you were going through this reporting format in the questionnaire and you discover something that that you're shocked that you've got some vendor, I'm just going to pick on China, for example. In China, in the say the Yugar region that's using child labor, you discover it and you stop dealing with them. You should elevate that to the very senior levels of your company, because under our act, it says that if you've discovered and stopped using them, you may be at risk for helping them supplement their income because you've taken their income source away. And so, Dan and I have talked about how does this come about? But I think it's meant for some of the very large companies that have, I'm not going to pick on any, but that have been in the media that have uncovered this. Now in Canada, if you uncover it, you may be borne with the costs of, because you've taken the livelihood away from these people. You may have to supplement them at the same time you need a new vendor. So,
it says any measures taken. So if there's no measures that were taken, I guess you could just report that, right?
yeah.
But this leads me to maybe pause for a second and think about what are the steps that a company might take to begin their compliance journey, if you want to put it that way. What is this? What is this going to look like? And I think first of all, it's developing a due diligence policy. Companies should develop a due diligence policy that outlines their processes and measures that they will take to mitigate the risks, right? And deal with the issues that the government has said that are important. And this should be in line with the law. So, and it has to be communicated to the relevant folks that are responsible for this issue within the entity. And then really do a gap analysis. What is the current state? What is the desired future state? And how do you fill the gap, right? Assess the supply chain. identify any potential risks, and then identify subcontractors or suppliers and consider whether or not they're adhering to international standards and regulations. And then implement, the due diligence measures, fill the gap, right? This may involve, for example, risk assessment, engaging with suppliers to ensure compliance, and implementing mitigation measures, the measures that David just referred to. What measures are possible here? Then further monitoring and evaluating performance. There is a requirement, we mentioned this, is it's important to the government to determine how effective are your measures. You've got these things in place. Companies should monitor and evaluate their performance, ideally, to ensure that their due diligence measures are effective in mitigating risks in the supply chain. And that may involve tracking supplier performance and conducting routine risk assessments. And then the publishing of annual reports. It's going to be important from a legal standpoint, and it is also going to be important from stakeholders' standpoint, because they're going to be looking at this. Civil society organizations, affected communities, investors, customers, all these folks are going to have expectations with respect to these reports. And finally, of course, seek external support. Businesses like David and Carson International can assist with the filing, the completion of information. Our firm assists brokers when things get into the too hard pile and the answers are difficult. And so it's important to make sure that if you put forward a report, it is internally consistent and that somebody with responsibility can sign off on it as being true, accurate, and complete. Because there are penalties, and they're significant ones, up to $250,000, I believe, for not filing and other things. So that's my 2 cents worth on compliance and how to start your compliance journey. On to the next page, please. So best practices, what are they? Develop an action plan, develop a policy, a code of conduct, assess areas of risk, provide links to possible internal and external reviews, have a public supplier list, and obtain information with respect to public disclosures or statements. Again, from a very simple standpoint, do a gap analysis. Current state, future state, what's the gap? So at this point in time, I guess I'll open it up and for questions. I just wanted to pause to say that this piece of legislation, there's several challenges with compliance, at least from my standpoint. There's supply chain complexity. Many companies have complex and extensive supply chains, and identifying and assessing risks can be challenging and can consume resources. Data collection, that's another issue. Data required to comply goes beyond regular operational boundaries, and it might not be within the wherewithal of a company to obtain all the primary sources of information. So it might come in different formats, and there might be an absence of data. The veracity of data, information from others, how useful is it? How much do you need to do to check the data to make sure that it's credible? Or do you have to do any independent verification at all? Lack of transparency. Many of the suppliers may be unwilling or unable to provide full transparency. Lack of capacity. Many small and medium-sized firms are going to lack capacity to really get into this issue of data collection from disparate sources of information. or credibly check information. The cost of compliance will be expensive for small and medium-sized businesses especially. And knowing what is enough is a difficult issue. Understanding what is required to satisfy the regulators is a bit of an unknown right now. So those are some of the issues that I see with the legislation, but the most important takeaway for this is to make sure that you file a report by the due date. And that's the key for this year, because it's the first year. And I think the government will be moving forward with this program in successive years. So in order to avoid unwanted attention, it's best to file a report this year. Over to you, David. Any comments?
Yeah, I'd say the first thing is, if you determine that you are in fact an entity, like Dan said, you need to file this year. So the penalties for not filing could be up to $250,000. So you need to file. You just have to file and be factual. The government just announced that this was taking effect last November, and it's retroactive. So don't make things up. Make the report and the questionnaire factual. This is one of those KISS simple ones. Just report it. If you haven't done a lot, then just report to them. I don't believe, and it's just my opinion, that there'll be a lot of background checks on the information submitted other than the filing. And so in subsequent years, they're certainly going to want you to make sure that your supply chain is robust enough that you're checking to make sure you comply with not using forced labor or child labor. But we're looking back in time. So keep it factual, keep it simple. The 10 pages to me is a warning that they don't want a lot of depth in these things. And the other thing is, this is going to be public information. So certainly keep any proprietary information out of your filings because it will be available online. And it's one of those. It's for brokers and the other brokers that are online. It's one of those things that we've never dealt with it before, and now we have to make sure that our importers of that size are aware of it. But it's something brand new, and you're gonna have to do it every year. So it's something that needs to be lodged. And if you don't have inside legal counsel, I'd say if you have inside legal counsel, they should be involved in some respect. A lot of firms do not have inside legal counsel. Then they're going to have to determine a position within the company that's ready for filing. And if you can't do that, then put measures in place and have somebody outside, like Dan's firm, do the filing for you. And then I've spoken to a number of brands in Australia, UK. They're very much in line because they're aware of this, because they have filings already in place in those countries. It's a matter of tweaking and making sure that Canada is on board with the same zest for their vendors, and they probably are. If you're a global brand and you're based somewhere else in the world, you're probably doing this already. I would say, tweak it so that you can comply within the countries, because there'll be other countries coming on board. And I don't think the intent is to have a different filing in every single country. So that just becomes unworkable. So I really think I'm actually shocked that Canada is ahead of the United States. They don't have this yet, but I wouldn't be surprised for them to adopt something like this within the next couple of years once they sort out the nonsense in the election in November. So yeah, my 2 bits worth.
Yeah, good points, David. I think that the big thing is just a report to avoid unwanted attention. And what's done is done. The big focus will be, I think, from past experience. None of us have the prophetic vision of a clairvoyant, but from past experience, I would say that the government will focus on the people that they think should have reported but didn't, as the first order of business. So, folks, I think we'll end it there. Taking a little longer than I intended, but I hope you found this session to be useful. I'm very glad that you've joined us today. If you do have any questions, please don't hesitate to email us, send a note to David or myself, and we'll be happy to assist and give you our thoughts on next steps. With that, I think we'll end there. I hope you have a great day. There may be a questionnaire that comes out. If not, please also send us any comments you have about what you found useful and any topics that you think we should elaborate on in the future. With that, all the best. Have a great day.
Yeah, thanks. Thanks again, Dan.